second discussion of the day, which is on the subject of non-price competition in digital markets. As we heard from Pedro this morning, digital markets has been a really major theme of the OECD's work, and certainly we're hearing a great deal of interest from the broad kind of policy-making community about how competition is evolving in digital markets and what we really need to do about it. And I think that, throughout all of the roundtables and hearings that we've held recently at the OECD, one of the big messages that has come out is that, on balance, the competition legislation framework, the kind of overall conceptual framework in terms of how we approach competition problems, and even for the most part, competition analytical tools, tend to be still flexible enough and fit for purpose to dealing with digital markets. And I think that nowhere is there a better example of this than talking about non-price competition in digital markets. So it's a very well-established concept that quality or innovation can be as important determinant of consumer welfare as price. I think that for years this has been a feature of cases, and this kind of framework of non-price competition actually allows us to deal with a lot of the emerging challenges that we're seeing in digital markets. So whether that's concerns about preserving the incentives of firms to engage in R&D, it could be even questions about privacy or exposure to advertising or the use of consumer data. So I think on balance, this topic really highlights how flexible some of the tools and certainly the legislation that we have are to adapting to these digital markets. That's not to say that there aren't some really big difficulties. And at the OECD, we've held two recent roundtables last year that kind of really shed light on some of these difficulties. The first being in June, we talked about the non-price effects of mergers. So there we explored innovation and quality, variety. And I think that one of the big messages that emerged out of that is that there's not a really simple unidirectional relationship between a merger and competition and these non-price dimensions of competition. So there really is a need to engage in a case-by-case analysis. Surprise, surprise, and basically, weigh the effect on the ability of firms and the incentive of firms to engage in innovation or provide a certain level of quality in a market. Another thing that we talked about a little bit is the question of privacy, and I think that at the very least, most agreed that we can't rule out that privacy might be a dimension of competition in markets. We also discussed some of the practical challenges in terms of how do you weigh qualitative and quantitative evidence, because non-price effects tend to really place a lot of importance on qualitative evidence, and the importance of capturing dynamic competition effects, both dynamic harm and dynamic efficiencies. And then in November, we had a second discussion, which was also very interesting, on quality dimensions in zero-price markets. And so here, one of the key themes that emerged is the need to kind of understand the business model that underpins providing a product for a price of zero. Is it to collect consumer data? Is it to get eyeballs on advertising? Is it to establish a consumer relationship that you can then turn into a paying relationship in the future? So understanding that is really important, and you can kind of find an equivalent dimension of quality that might be important to consumers in those cases. Two other things that we highlighted in there, again, the practical challenges that are associated with a price of zero. So it's very difficult to establish a dominant position, to look at market shares when you don't have a price. And more broadly, I think another key theme that emerged is the fact that a lot of the issues that we see in zero-price markets may not neatly fit into a competition enforcement framework. And so that doesn't mean that competition authorities have nothing to do. In fact, it's very important for them to actually put an emphasis maybe on advocacy or cooperation with their colleagues in consumer protection or data protection authorities as well. So I think that we're going to explore some of those themes today, and I think that we're very fortunate to have an excellent panel to do so. So I'll just introduce them. The first is Giulio Federico. He's the head of the Empirical Analysis Unit at the Office of the Chief Economist at DG Comp, the European Commission. And Giulio has been a very key driving force in developing the empirical approach and the conceptual approach to how the Commission deals with innovation and mergers. So we're very lucky to have him here. Next to my right is Jorge Padilla, who maybe needs no introduction, but Jorge is the Senior Managing Director and Head of Europe at Compass Lexicon. And of course, Jorge was one of the invited experts at our non-price effects of mergers panel in June. And finally, last but certainly not least, is Dan Rubenfeld, who's Professor of Law at NYU and Professor of Law and Professor of Economics Emeritus at University of California, Berkeley. He's written on a lot of these issues and has been a frequent participant at the OECD as well. So I think I'll just get right into some questions to stimulate some discussion. And I think the first thing that I wanted to talk about a little bit is innovation. So I'll turn to you, Giulio. I mean, I think that one of the challenges that we keep on hearing is the need for competition authorities to capture dynamic competition effects, especially in mergers. Obviously, not a straightforward thing. You can imagine there's a simple stylized example of a merger between two firms that are engaging in R&D. They both have a well-defined path. It's for a well-defined product that is close to commercialization. The merger is going to eliminate one of those products. And so the harm is very clear. But I think most times in the real world, the fact pattern is not so simple. Oftentimes, maybe you have a lot of uncertainty, or you may have innovation competitors that exist outside of a product market. So it's very challenging. So Giulio, can you talk about how the Commission kind of overcomes these challenges and how you avoid an accusation, let's say, that there's subjectivity in trying to capture innovation effects in mergers?
Thank you, James, and thanks to the OECD for the very kind invitation. It's my first time here, so a real pleasure, and as usual, I speak in my personal capacity. So just two reactions to your question. The first, how do competition authorities look at dynamic competition? That's like saying, how do they do the actual job? Because competition is a dynamic concept, and inherently, a healthy competitive market is a healthy, dynamic process where firms seek to outcompete each other, take sales from each other via price cuts, via cost reductions, via the introduction of new and improved products. So the fundamental nature of competition is dynamic, and therefore the question of how we address this issue is the raison d'etre, in many ways, of competition policy. Policy should be the heart and soul of our activity and conceptual thinking. In that sense, Schumpeter was absolutely right. When he wrote about that in 1942 and was a bit upset that some of his fellow colleagues were a bit too concerned about static competition, I think he very much had a point. Now, then, given that, though, some of these effects on non-price competition, dynamic competition, are harder to quantify than price effects, it's not a coincidence, no wonder that a lot of the academic and maybe some of our enforcement too tends to start first under the lamppost where there is light, because that's easier, and also in academia it's easier to publish if you have a paper that can quantify things or solve a model. But the keys may be away from the lamppost where it's a bit darker and you have to go and look for them. And then evidence may be more qualitative. You may have a proxy for the number of competitors with the required capabilities. Market shares may not be completely informative. The proxies may need to look more at the supply side of a market. What kind of assets are key? Is a track record in the market key? Is IP and patents important? So you have to look around for alternative measures of concentration, if you may, than simply market shares that can work in a static framework. However, conceptually, I think it's very important to be clear about what are the kind of effects that a merger is driving, what kind of externalities is internalizing. Because a merger clearly stops two firms, from competing across all dimensions of competition, price, quality, cost. So internalizes business stealing effects, negative externalities in a sort of obvious way. That effect of internalizing business stealing tends to be anti-competitive in the sense it tends to harm consumers, because business stealing effects are about taking away consumers from your rivals by offering them a better deal. If those effects are suppressed, at least between two firms, consumers tend to be harmed, and weigh them against possible pro-competitive effects of coordination which could be internalizing a positive externality, for example, a knowledge spillover, or bringing about complementarities in R&D or in cost. So when you come to the empirical assessment or evidentiary assessment, you want evidence on the strength of business stealing effects, barriers to entry, concentration capabilities, closeness of competition, diversion, and the strength of diversion effects, and evidence on the complementarities, on knowledge spillovers, how important is the intellectual property regime, is it able to internalize those positive spillovers already or not? Do the merger does it bring about complementary assets that can enable better, faster, and more effective innovation? So in that sense, my message is one of sort of business as usual, if you may, because these key drivers are familiar to us from unilateral effects in static markets. Clearly, innovation is a more multidimensional issue. Externalities of different types interact with each other. You have to keep track of those. But the fundamental framework of business stealing effects being internalized and leading to likely consumer harm, and pro-competitive effects due to synergies and complementarities and spillovers being internalized, driving consumer benefit, that fundamental principle and framework is fit for purpose also for innovation and dynamic competition.
Thank you very much. Let me turn to maybe Jorge. I mean, when you're advising clients, do you think that you have enough to go on in terms of a framework for presenting the overall effects of innovation from the merger?
Innovation is a complex dimension. You need to understand what your clients are doing, what are their pipelines, what kind of R&D projects they are undertaking. And it's a dimension of competition that is less easy to summarize than a price. But having said so, that doesn't mean that cannot be analyzed. One can look at what are the R&D resources that the company relies upon, or the companies, the parties rely upon. What assets do they have? What kind of projects and products they are engaged in? What are their pipelines, and to what extent they see their pipelines overlapping and competing with the pipelines of competitors. You can measure how strong innovators they are by looking at their patenting activity, the extent to which their patents that they produce are of high quality because they collect significant citations. And you can look in all those dimensions to see whether the merger is going to generate overlaps in the innovation dimension and not only in the product space dimension. Ultimately, when you look at the innovation dimension, you're looking at the product space in the future, because those innovations are going to translate into future products that will be launched into the market. And therefore, looking at innovation is nothing else but trying to lengthen the viewpoint of the competitive assessment so that you don't look only at static competition, but you look also at forward-looking competition. One reflection in this respect, what we try to understand is whether the combination of the R&D assets of the companies is going to be pro-competitive, is going to generate spillovers. It allows the internalization of those spillovers. It increases appropriability in ways that are going to lead to more innovation. Or what we have there is the possibility of substitution. What we observe is that the pipelines of the projects or the different merging parties are substitutes, and therefore the likely effect of the merger would be to streamline or to reduce innovation. Now, it is important to keep in mind that although in many circumstances I agree with something that was said in the previous panel, that there is a trade-off between quality and quantity or quality and price, in some occasions that's not the case, and they go in the same direction. In the case of innovation, companies tend to innovate because they want to escape competition. We are more or less all somewhat lazy, and if you don't face competition, you enjoy your idle life. If you face competition, you want to differentiate your products. The fiercer price competition is, the lower the prices are, the more likely you have the incentive to differentiate your products in order to soften competition. And therefore, in those cases, innovation and price competition are not, there is no trade-off between price competition and innovation competition. Both of them are aligned. And that's what we try to understand when we are doing a merger case. Do we see that in this particular industry, and given the characteristics of this merger, we're going to be in the world in which innovation and price competition are in a trade-off relationship, or are they in a situation in which they are moving in the same direction? Because then, if that is the case, we're going to have to think about which remedies we structure to deal with that future competition problem, and not just with the static competition problem.
So, Dan, maybe some of this language, some of the terminology is maybe slightly different in the U.S. I know that oftentimes there's talk about the definition of, innovation markets maybe, or trying to, bring this consideration into different parts of the competitive assessment. Can you talk, does this still sound broadly consistent with the approach that you've seen in the U.S.?
Everything my prior guests have talked about really applies. It's true that going back 20 years ago in the U.S., we distinguished between innovation markets and R&D markets. My experience is that the concept of innovation markets really never caught on. So I've seen very few cases that rely on innovation markets. R&D markets, however, are in some cases useful. And I want to talk about that briefly if I can. When the agencies are looking at innovation, one of the things they want to try to figure out is this innovation that's closer to the views of Schumpeter as opposed to the views of Arrow, if I could simplify. So with Schumpeter thinking innovation really is done by the bigger firms who have the resources to really make the innovation work. Arrow's view was probably leans towards smaller firms competing with each other, and the competition really drives innovation, and the resource constraint is not so serious. Those issues have usually been developed in the concept of R&D markets. And I can just give you one quick example. I'll give you several, but one quick example that I found really useful. I happen to be looking carefully at a merger the FTC wanted to evaluate about 15 years ago when Tim Muris was the head of the Federal Trade Commission. Excuse me, and the merger was between two pharma companies, Genzyme and Novozyme. And they were both competing very aggressively to develop a cure for a so-called orphan drug product, a very rare but very serious disease. And when the merger had actually occurred because it didn't quite hit the requirements for filing, but there were a lot of complaints, and the FTC looked at it, and the parties already merged, and it turned out that they had two different avenues of attack to research this problem. And the question the FTC wanted to think about was going from 2 to 1 going to reduce the line of attack for one, or would they pursue both lines, and which one was most likely to be successful? My own view was that this was the kind of Arrow competition that we looked for, that there were two different modes of attack. We couldn't be sure which one would win, and and the competition would be good for consumers, and therefore, had I had an opportunity to act earlier prior to the merger occurring, I probably would have recommended blocking the merger. But the merger had occurred, and after the merger occurred, and all this is written about in Tim Muris's description of the case, the Genzyme, which acquired Novozyme, hired the head of Novozyme to be the chief of research, and coincidentally, he had two children who suffered from this rare disease, and his deposition was the most powerful deposition I've ever read. He said that he was absolutely convinced that his children's lives would be better because he had chosen the right line of attack. So that pretty much killed the chance of bringing the suit, but it also pointed out that specific evidence can often tell you which line of attack is better. And so that's how innovation markets really work. If you want to look at another case, innovation markets came up in a recent DOJ examination of an acquisition by Nielsen of the leading, Nielsen, which does ratings for television. They acquired the rating agency for radio, and the DOJ was trying to figure out what would happen for ratings on streamed digital television and music. And both companies were innovating, and the question was what to do about this innovation market. and the DOJ decided that the merger could go through, but imposed certain remedies which would assure that both sides had access to IP. So we have examples like this where innovation markets have turned out to be pretty useful, and much more useful than actually trying to push everything into the older definition of product markets.
So, Giulio, let me maybe go back to what Jorge had mentioned as well. This is the case where there might be a trade-off between price and innovation effects. And kind of just following on what Dan was talking about, this kind of idea that careful design of remedies can be really important. Is that a situation in which there is an obvious remedy when there is a real trade-off between kind of price competition and the ability of firms to engage and innovate, while you have a concern that maybe their incentive to engage in that kind of risk-taking innovation might be attenuated by the merger?
Right. Well, I think so. Two points. One on the nature of the trade-off, and two on the remedy. On the nature of the trade-off, it really depends what is the driver of the trade-off. Is it a pro-competitive effect, meaning a cost reduction in R&D, which increases innovation, but yet doesn't fully compensate for an increase in current prices, say, or rather coexists with a current price increase? Or a spillover being internalized such that innovation goes up, and yet prices also go up? Or is it fundamentally an anti-competitive mechanism? And there are models in economics where actually the reduction in price competition between firms, so the internalization of price-based business ceiling effects, is so strong that it outweighs the innovation business ceiling effects and leads to more innovation. Now, in those models, consumers tend to be harmed anyway. So there's no trade-off actually to consumer welfare. It's just that the composition of their welfare changes post-merger such that they pay much more for something that's a bit better. Now, in that circumstance, there's no trade-off in terms of competition enforcement, and the remedy you need is a remedy that needs to restore future competition in innovative products. So you still need the R&D assets to enable a divested business to replace and replicate that future competition in innovative products. So I think, so it's really important to understand, is there a pro-competitive, so pro-consumer source for this trade-off or not? And then is it sufficient to outweigh the harm? Now, if it doesn't outweigh the harm, the next question is what kind of remedy is needed? I think the big distinction there is a pipeline remedy sufficient, or do I have to go upstream to the underlying R&D capabilities? Now, consider two opposite situations. A situation where you have lots of R&D competitors, let's say 8, but 2 of them happen to overlap at the moment in a product pipeline combination. For the next 5 or 6 years, you will have, with competition, you would have product market competition in that product once the pipeline comes to market. Without the merger, you may get a discontinuation of the pipeline. Now, in that case, a targeted pipeline remedy maybe will be sufficient to restore competition, because you don't have a problem of R&D capabilities. It's just that the stochastic nature of innovation is such that these 2 firms happen to be the only 2 on that product today, just because R&D is uncertain. Now, then flip to a situation when you only have 2 R&D competitors. They happen to overlap also in pipelines and products. No coincidence. They're the only ones. Now, in that situation, of course, a pipeline remedy will resolve the symptom of competition, but not the underlying cause. And you have to actually go upstream to underlying cause in that case and actually divest the upstream R&D capabilities. And that's very much what the Commission thought in some of the recent agrochemicals mergers, Dow, DuPont, Bayer, Monsanto. If you look at the DOJ complaint on Bayer, Monsanto, it's very much in the same direction on seeds and traits and weed management systems. If you look at applied materials, Tokyo Electron, another interesting case from the DOJ a few years ago, which was written up by their economists in the Review Industrial Organization, that's fundamentally the issue is, when we look at overlaps, is this a symptom of an underlying competition issue that's going to be suppressed from this merger? And hence, do I need a remedy that really replicates the entire set of required capabilities to be an innovator in the future product market, as Jorge put it? So it really depends. Again, you have to, as an authority, understand, as econometrically you would say, the data generating process behind the overlaps you see. What process generates those overlaps? Is it a process that delivers competition in the long term and that you want to preserve?
Okay, well, we've done the incredible, which is we managed to get 3 people on the stage to agree on innovation. That's remarkable. No, that's fantastic. I want to move to another subject because when we're talking about non-price competition, innovation in some ways really only scratches the surface. So another aspect which I had alluded to already is this question of zero-price markets. Now, Dan has written a couple of really insightful papers that focus kind of on the question of data. Data not only as kind of a competitive asset that can be used as an entry barrier, but also data is something that kind of undermines the ability of consumers to make rational decisions in markets and causes markets to not necessarily work in the way we would expect them to. So Dan, can you tell us a little bit more about that?
Sure. Just thinking about data gets one to think sort of in a slightly different dimension, because as one collects large volumes of data, one creates not only economies of scale and maybe economies of scope, but as I'll talk about perhaps later, you can actually get economies of speed, because getting data quicker gives you a comparative advantage over your opponents. So the world changes when you start thinking about the volume and the breadth and also the speed at which people acquire data. And often when you have the data or you're making use of it, you're selling things at a zero price. So what I wanted to do is just, if it's okay, I want to tell you my reactions about what happens when I see a zero price. And some of what I'm going to say probably will be controversial. First of all, my initial inclination is it does not make sense to talk about a market in which there is a zero price. And the reason is, well, there are a lot of reasons. One is it's a little hard to work with a standard methodology for applying SNP tests and hypothetical monopolization tests to define market definition. But more importantly, if there's a zero price in a world where we economists believe that people are maximizing something like profits, you have to look further to see where the action is. So I have a list of 5 things I think about when I hear it's a zero price. And the first thing is, maybe there's a two-sided market and the real price is on the other side of the market, and we could think of lots of examples on that. And if it's a two-sided market, it could be that the firm that has a lot of data and maybe makes it available or a product available at zero price is still profit maximizing, but the action is on the other side of the market. So there is going to be a relevant market, but the market will include something other than the data. So as an example, I believe that unlike, I think, the European Commission, I believe that there is no market for search per se, that the relevant market would be search applied to advertising generally or search applied to particular forms of advertising. Now, that doesn't change a lot of the concern that the European Commission and the U.S. authorities have about firms that have a lot of data and have a large share of search, but it changes the character, I think, of how you analyze it. So two-sided market comes up first. The second thing that comes up in mind is bundling. If it's a zero-price product, maybe it's bundled with something else that has value. And as you know, that's led to a lot of cases. In Europe, the Windows Media Player case against Microsoft, that's an example of that. It's slightly different than the U.S. Case against the operating system, the browser. Third thing is the products may be an experience good. It may be something you want to learn about, and eventually once you learn about it, you'll price it at a positive price. Fourth thing, maybe you want to collect data because you can, as I say, you can, with speed particularly, you can have an advantage by creating your own network effects. And fifth, in my mind, there might be predation. It may be the zero price is really just a form of predation, and you're planning to take advantage of that to injure someone and eventually gain market share. So zero prices, particularly with data, turn out to be important, and partly because when there's a lot of data, the data does give you, does create network effects, does give the potential to do a lot of terrific things, but also the potential to do something harmful. So everything is magnified in my view. The efficiencies are often magnified, but so are the potential harms. And the zero price gives one confusion just because we can't simply use zero price to do snip tests and other things. And I've suggested variations of how to work with zero price, but I think the easiest answer is to figure out what the strategy is that underlies the firm that's pricing something at zero, and then to use the traditional analysis. And I have to confess something that economists usually don't want to say publicly, which is that I find it really useful to try to look at the actually intent of the party that is pricing a product at zero. That's not something economists normally have a specialty in, but I find that intent is often realized, at least if you have access to enough materials, either in the form of what people say in documents, which is what they used to say when we investigated Microsoft 20 years ago in the United States, where they specifically said they plan to monopolize the market. But more directly, economists can infer intent by just saying such and such behavior is consistent with profit maximization. And when you're looking at intent with that in mind, you can often sort out which of the 5 stories I told you about a zero price, or probably another 5 that I haven't told you just yet. I'll save for another time.
So, Dan, I think one of the key things that you touched on is this importance of multi-sidedness in markets, and I think that I personally cringe every time I read somewhere where someone's analyzing a multi-sided market. There's a zero price side and a paid advertising side, let's say, and there's a claim that the paid advertising side is perfectly competitive, and so our work here is done and everything is fine. So, I guess my question, maybe to both Giulio and Jorge, would be. What do I do? So how do I establish dominance on the zero price side? Because I don't have a price, I don't have an obvious market share, and it's very difficult to show that market power really registers in terms of a price side, so it's more in terms of these qualitative aspects of the conditions that are applied to data use and privacy protection and things of that nature. What should I do?
So I'll start answering that question and disagreeing with my friend and colleague Dan. I do think that there are markets where prices are zero, and there are relevant antitrust markets. In fact, in many of those markets, the fact that the price is zero may indicate that there is market power, because in the absence of market power, prices could be negative. And there would be subsidies to the consumers to attract them to the platform, so that then one can sell on the other side of the market. So to me, the fact that there is a zero price or a negative price or a positive price doesn't mean that there is no market. I think that what we need to understand when we define markets is whether the actions of a given company, which may be on price and non-price dimensions, are constrained, and identify what are the competitive constraints. It may be that one doesn't have that much market power on the price dimension, but may have very significant market power on non-price dimensions. And therefore, the logic which we use to define markets traditionally, which is the snip test, wouldn't work that well. But that doesn't mean that we cannot see whether significant degradations of quality, significant degradations of privacy could have an impact. The risk of not considering or thinking that whenever we observe a zero price, we need to look at two sides of a two-sided market or so, is that we may be actually adopting a very narrow perspective that makes sense from the viewpoint of a given business model, but it doesn't mean sense across business models. Companies may compete in a market with different business models. There are people out there that compete offering, for example, mobile operating systems for free because they monetize in the online advertising market. But there are people that compete in the mobile operating system market with a business model that is not two-sided, that basically is the result of trying to license those operating systems as a price. What does it mean? How do we then deal with the fact that there are different business models? My view is that that requires that we look at each side of the market. There may be circumstances where everybody uses the same business model, where there is the same monetization, and the competitive constraint cannot be understood without looking at two sides of the market. But in my opinion, that's on a case-by-case basis. And for example, as regards search, I think that there is a separate search market, and I think that there is a separate online advertising market, because there could be search businesses that get monetized in a different way, and in fact there are search operations not that successful, one has to reckon, but there are search engines out there that try to monetize in a different way. And that's why I think that that would answer also your question about how we should proceed. My opinion, we should proceed not by restricting attention to a given business model, but looking at what are the sources of competition, what are the sources of market power, and seeing whether market power exists because of the absence of competitive constraints.
Before you move over, let me defend myself. Actually, Jorge and I agree largely with what Jorge said. But I just want to, my statement that there shouldn't be zero-price markets was meant to be overly provocative. But the discussion we've had raises an important point, and that is, in a lot of these markets where price is zero or something very low, quality of product turns out to be important. And so we have to start looking harder at quality as well as price as a significant determinant of what the product is in the market and how the firms are behaving. And that can change the story. So you could imagine, for example, in search, you can imagine a market where the search may be free at some level, but the quality varies substantially depending on the goal of the search, the magnitude of the data collected, how it functions, and so on. And now we're talking about an area where you can easily talk about competition.
Well, just to go back on to the issue of measuring of market power and theories of harm. I mean, my first reaction, I kind of agree with Jorge that you want to keep the markets separate because we're not really talking about substitutes. I think Mike Katz has a very nice paper inspired by the Amex case where he discusses this issue at length, and I think I agree with what Katz more or less says, and I think also he contributed one chapter in one of your books along the same lines. But on the free side of the market, I mean, of course, I would look at what the firms use themselves as metrics of their success. So if you look at these large platforms, number of clicks, traffic, monthly average users, daily average users, so how much users engage, are very important metrics of their success. But still, at least as a first cut, when looking at theories of harm, I think the paying side would probably be the first port of call, because I just looked in preparation for this at the latest quarterly results of Google and Facebook. Google made 120 billion of advertising revenue last year, so that's not bad for a free market, a free good market. Facebook made 60 billion, and it doubled its revenues within 2 years, from 30 to 60. So clearly, there's enormous effective data monetization taking place on the back of some of these free goods. So that seems to be the natural port of call to understand for a given conduct or merger, is online advertising becoming more concentrated, or are some of the strategies aiming at protecting that significant position, apparently significant position? And here I'm talking just about financials. I cannot tell you the market shares or anything about market power, but clearly there are significant rents here being earned on the paying side of the market. And clearly, as economists, when you have a zero-side price market, you suddenly very quickly fail on the one monopoly profit theorem a la Chicago, that you basically have a capped price. Maybe the market price should be negative, it's capped. The moment a price is capped, Chicago fails. Already you open up a number of avenues for potential theories of harm on exclusionary conduct. As Dan says, you very quickly have multi-sided markets, and hence contracting externalities, in the sense that users on one side of the market may not internalize the exclusionary effect of a given conduct on the other side of the market, and therefore may be easier to compensate one side to exclude on the other. And you also have these very strong, potentially strong network effects at play, which means that if you exclude a rival by a conduct, you automatically make it less competitive and raise its costs by depriving them of demand-side externalities. And that's quite a powerful exclusionary leverage or tool that in a traditional market you don't have. It's actually, if I'm competing on a steel market, and Jorge is my competitor, I find it quite hard to increase his costs. I can't go into his plant and remove a line. Whilst with network effects, simply by taking users away from him, I can increase his costs and make him less competitive. That can enhance the potential for anti-competitive exclusionary conduct. Again, I think my cats in the chapter in your book really goes through these factors. I think it's quite a convincing account.
Can I just add something? I have a lot of sympathy for the enforcement authorities like yourself, because particularly when data are involved, because when a firm does an acquisition that gives its access to a source of useful data, particularly in a world where speed matters, it may well be years before that firm figures out exactly how they can most effectively utilize those data in terms of providing new products, new services. And all of that may be pro-competitive, but to the extent that there would be some behavior that would be harmful to competition, it may not occur for years, and yet the agencies are typically giving themselves roughly a 2-year sort of horizon for thinking about the likelihood of harmful effects. And so my concern for my friends who are like yourself, who are still working within the agencies, would be you've got a tough problem in an acquisition that's vertical, involves the ability to collect important sources of data, but you really can't be sure whether the benefits of those data will be really substantial or whether there's the possibility of anti-competitive injury.
I was going to say in that respect, I think that that's a very important and significant point. There are, however, sometimes pieces of evidence that you can collect which are not standard but could be helpful. So, for example, if you talk to venture capitalists in Silicon Valley these days, you're going to learn the notion of the killing zone. And that's space and the product space surrounding certain big platforms where they're not going to fund any entrant because an entrant there is likely to be killed. Now, that killing zone is interesting because if we were able to learn more about it from venture capitalists, we would have an idea about which startups, if acquired, which acquisitions of startups could be potentially anti-competitive because they are in the killing zone. They are therefore perceived, at least by the venture capitalist community, as challengers, and therefore their elimination could be potentially anti-competitive. So in this new world, we're going to need to learn new things, new notions, and look for different and new sources of evidence in order to be able to deal with what I fully agree with Dan is an extremely complicated forecasting prospective exercise.
I think you've kind of actually almost answered my next question, which, or at least given a partial answer to the next question, which is, I think we can all agree that non-price competition is extremely important in these digital markets. There's a range of kind of parameters of non-price competition. How are competition authorities to choose amongst them? How are they to decide what really is a legitimate dimension of competition from the perspective of consumers and from the perspective of firms? And I think in particular, we had a really interesting discussion in June about the concept of privacy. And so there's the one side of the debate that says that this is really a consumer protection issue. Competition authorities should not be inserting themselves into this type of concern. And in fact, they may actually be guilty of making a decision about what consumers should care about rather than what they actually do care about by revealed preference and by their behavior. But on the other side, I think that there is a growing appreciation for these potential alternative dimensions of competition. I think, the European Commission has looked at in a few cases, LinkedIn, Microsoft, for example, the fact that there can be these alternative dimensions. So where should we go for the evidence other than maybe a venture capitalist? But how do we root our understanding in the dimensions of competition that are really important, especially when you don't have a price involved?
Well, I think that ultimately we need to, and I think that this is a point that Paolo made before, we need to go and talk to the companies and understand from the companies how do they compete. It is very clear in these days that many companies with very clearly identified business models not only compete on price, but they compete by collecting data that they can monetize or data that can help them in order to improve products and services. And to some extent, we want them to do so. So how do we identify the dimensions of competition? Talk to them, see what provides them with a competitive hedge vis-a-vis competitors. The extent to which we worry about data is because, contrary to what happens with price, where we seem to be happy with companies offering the products as cheaply as possible, In fact, we would be happy if we were subsidized for consumption. We are worried that the collection of data can be excessive, that data can be collected to a point that actually undermines consumer welfare, and undermines consumer welfare because people don't want to see certain information made publicly available, whether their health conditions or whatsoever. And I think that's the difference. It's a dimension of competition which we can elicit from talking to the companies, but that we may want to constrain, and we want to constrain through privacy regulations, etc., because we think that at some point what is positive, the collection of data in order to improve products and services, may become negative if it goes excessive, both in terms of the identity or the quantity of the data. And that's again, something that we can only learn by talking to consumers and firms.
Let me just, I agree with what Jorge said. Let me expand on it a bit. When one thinks about, I think, the imposition of regulations like the regulation we have here in the European Commission, European Union, when you impose a regulation that protects privacy and gives individuals the right to sort of choose to whether have certain data be made available or not, you have to realize, and that's a job that I think largely falls outside the competition area originally, but you have to realize that any decision made about how privacy is handled will typically have competitive implications. So, for example, if you pass certain regulations that say that people have control over whether data are made available, that will make it harder for certain companies that would have access to that data to move quickly, to innovate, to produce new products. But it will also change the benefit in terms of speed, the economies of speed, for other companies that may have a different angle. And so you're going to change the competitive mix. For example, hypothetically, let's say you come down really hard on Facebook. They've been in the news recently with good, perhaps not such good reason, maybe good reason. And you come down really hard on Facebook in limiting their ability to cause injury in terms of privacy. You may benefit companies like Microsoft or Google or Amazon, who will then find they're not as heavily restrained, and they can get other data, related data, with speed and act on it. So we have to think, as we're imposing desirable restrictions on privacy to achieve goals we all think are very important, that there will be competitive implications, and we really need to combine the two when we're making those kinds of decisions.
So, Giulio, what do you think the role of competition authorities is in kind of preventing those unintended consequences of maybe well-meaning regulation? And how is there a role for competition authorities to help design regulation that actually stimulates competition on these non-price dimensions rather than potentially restrains it?
Sure. I mean, I think clearly that there are a number of objectives here, and there's also a sort of consumer protection angle from some of this regulation because of the strong asymmetry of information that users face in a product that's highly complex, and the firms themselves seem to be discovering the potential for some of this data collection and data matching across sources as we speak. And I think they do it, of course, without any regulation. They would do it to maximize the monetization potential of that data, and constraints for consumer protection reasons can obviously limit that. And then obviously you think about kind of theories of harm, for example, on conduct. I mean, for mergers, maybe it's a bit more straightforward, but for conduct, how does policy on data and portability and privacy affect monetization and foreclosure issues? I mean, I think I agree with Jorge. We need to really understand more here. I mean, at least I don't understand enough about machine learning and AI to understand how this data is used, how much inference, statistical inference, is performed across users to really match a given query by an individual to the set of advertisers who appear on that page when the query is then sort of answered. I suspect there's lots of very targeted matching, which is really increasing the data monetization of some of the platforms. And again, as I mentioned earlier, creates really a barrier to entry for firms that have much less data availability, and creates a vicious circle that is very hard then to attract organically these users to be able to match that type of data monetization. So I think we probably need more intelligence here to understand what's happening within the firms. And I get the impression also from these financial results I mentioned earlier that things are moving very quickly, that the firms are learning as well much better how to automatize this process and make it very effective for at least in terms of profitability.
Okay, and I might actually just open up the floor to questions unless anything else to add. So please feel free. Oh, yeah, please.
One point, I mean, we discussed, and Dan was so sympathetic to our travails at competition authorities. I mean, I fully agree that, we started at the beginning of the conversation with some of the easier markets, so pipeline products in a well-structured development process in pharmaceuticals and agrochemicals. I think, horizontal mergers in those sectors are much easier than mergers or conduct in some of these digital markets. So, having lived through the last 2 years of controversy from the Commission's enforcement action on agrochemical, I have a plea that, we need to first, as a collective community, manage to agree on the fundamental principles on those easier industries before even we start tackling this much more complicated and more fast-moving in many ways sectors. So I think maybe again from your work or other people's work, I think to come together and at least understand what the fundamental principles are for assessment of in the more traditional innovative industries. So traditional but yet innovative, because products evolve over time. I think that would be very useful.
Can I ask you what you think that would look like, Giulio? Do you think that, is it an empirical shortfall that we have right now? Is it a problem kind of connecting markets with the legislation that we have? What would you say is the biggest?
On digital?
Yeah.
No, I think it's, as Jorge was putting it, it's really much understanding. I mean, I think the issues in digital is that these smaller firms don't have a concrete pipeline product that you can point to yet, and the capabilities they have are uncertain. They may have lots of users, for example, but you actually don't know whether that user base is going to be a substitute in the future, as Dan was saying, in a few years' time, for the large platform. So you do have a real problem of assessing closeness and capabilities. Ultimately, you want to apply an expected welfare standard, consumer welfare standard, so trade off the type 2 and type 1 errors. So is there a genuine pro-competitive effect here, which increases the cost of over-enforcement, or is it just a small chance of a very large consumer benefit without the merger, and hence a large consumer loss with the merger? So I think a narrow cost approach is the right way to go because of the intrinsic uncertainty, but yet, whilst in agrochemicals and pharma, I can point more, I can touch some of the capabilities of some of these firms in terms of patents, pipelines, engineers, track record. Here, that's much harder.
I can give you a quick example of how hard it is. I mentioned before and this is all, I'm pretty sure, public in various discussions have come out. So when Nielsen was acquiring Arbitron, this is TV ratings and radio ratings, it was clear to the government and clear to Nielsen and Arbitron that the real reason the merger would make sense would be because the combined company would be best able to figure out how to find ratings for everything that's streamed on television and radio. So everyone knew that's where they were aiming, but no one actually knew exactly what kind of data they would collect because it was too early. They were trying experiments, new ideas. And no one actually knew ultimately what product they would have. So imagine that you were at DOJ, which handled this matter, and you're trying to decide what the problem is. And you are concerned because you have Nielsen has a lot of market power in TV, Arbitron has a lot of market power in radio, and you're putting them together, but no one knows exactly what the product's going to be. No one knows exactly what the data will be collected. The parties themselves don't know, but they're willing to invest a lot of money to try to figure it out. And that makes the job the regulators have very difficult. Ultimately, the deal did go through, by the way, if you don't realize it. There were some restrictions concerning IP, but I think, in fact, the Department of Justice was correct not to try to impose any remedies any stronger because They just have to wait and see how the market evolves. And I actually haven't seen enough of the ratings yet. They're still doing R&D now, so we'll have to wait a few more years.
Jorge, do you want to add something, maybe just on dealing with this uncertainty when even the parties themselves maybe don't know?
Actually, what I wanted to do before inviting people from the floor is to talk about something that was mentioned briefly by Giulio. And this is, well, if privacy is a concern, is this something that we have to deal with consumer protection, or there is a competition policy dimension? And I want to argue that in many circumstances it would be a consumer protection issue, but there may be circumstances where it becomes a competition policy issue. And let me give you one example. This is an example of a situation in which a company is able to collect data in one market that can be used actually to obtain a competitive advantage in an unrelated market. You may not know, but actually the credit scorings, the scorings that one company is able to establish for any of you, when you're contemplating asking for a loan, are much more powerful if they are based on, instead of using credit rating information, publicly credit rating information, they're much more powerful if we use data on your mobile use. And we know which phone you have, we know which type of contract you have, we know how you pay, etc., which apps you are using. Guess what? Imagine that you're using 3 or 4 apps from private banking solutions. We can use all that information and we produce credit scores that are much more powerful, much more accurate than anything that is out there from credit rating agencies. Now, that's information from one market that can be used to obtain a competitive advantage in another market. Is this something bad? Not necessarily. Now, what was the way in which the information in the first place was obtained? Was obtained because, for example, certain terms and conditions used by a company that had very significant market power and could not be replaced, could not be turned down without sacrificing the use of that product in question. Well, if that is the case, then the reason why privacy was degraded or data was collected, depending on whether you want to see it half full, half empty, was the result of market power, because otherwise, possibly, you would not have accepted all that information. That means that there is a competition dimension because the origin or the nature of or the reason why the data can be extracted, it is because of market power. Now, maybe we don't worry about whether those terms and conditions are abusive in themselves. Maybe we don't have an exploitative concern. But even if we don't, we need to understand what are the implications on the other market. Because it may be that that data that is collected and cannot be replicated can be used to obtain a competitive advantage that cannot be matched, that cannot be replicated at all. And that is what we define as a distortion of the competitive process. Now, that's not enough to conclude that there is something anti-competitive. We will need to see what is the overall effect on consumer welfare. It may be that that way of entering into an adjacent market leads to more competition and more consumer welfare, but it may not. And those are situations where consumer protection is not enough, and we need to look at competition, because competition is the one that can tell us whether there has been exploitation and whether that exploitative abuse can have exclusionary implications. So for those that argue that it's all about consumer protection, I think that that's not true. I must say that also I'm somewhat frustrated about that debate, because when you argue consumer protection, somebody tells you you should look at these from the perspective of competition, and when you say these problems should be tackled from the perspective of competition, the very same person tells you you should look at these from the consumer protection angle. And I, being a simple economist, get really confused about that.
That's a wonderful segue to, I think, a classic OECD message that we always have, which is the need for these different regulators to come together, because I think oftentimes there may be a sense that the other regulator is dealing with it. Both sides think that's happening, and maybe something will fall through the cracks. And so it's a great example of why at the OECD we had a joint meeting between consumer protection and competition authorities, at least to make sure we're speaking the same language and start to bridge those gaps, because I think in most cases they're actually complementary rather than opposed objective. So we have a few minutes for Q&A. So please do raise your hand if so. We've over there.
Thank you. I'm Andrea Pizzoli from the Italian Competition Authority. Just remaining to the example that Jorge provided, and I mean, regardless the potentialities of the dual competence, we spoke about that so many times that I don't want to stick on it. I'm quite interested if the concern, Jorge's concern, is more on the exploitative character of the strategy he illustrated, or on the exclusionary effect on the other market where the data could be used. Because otherwise, I mean, if we look at the zero price segments or the zero price markets, I mean, we are usually much more constrained to the exploitative character of the conduct. Whereas, I mean, it is not that comfortable, even if the afternoon have to talk about that. But
yeah, actually, my main concern is the exclusionary part of the story. And it's to the extent that I'm concerned about exploitative terms and conditions is because I think that that provides a competitive advantage that then can be leveraged into another market and cannot be matched. So ultimately, my main concern is exclusion, but the mechanism works because there is market power in a market that allows that company to extract data and obtain a competitive advantage that can be leveraged elsewhere in a way that may not be replicated. And again, I'm saying this, I should caveat, at the end of the day, whether or not that's anti-competitive is going to depend on a consumer welfare analysis.
Presumably, you know, in a vertical merger, that issue may arise, right? If your phone provider merges with a credit rating or whatever it was player, then you get this access to this fundamental input, perhaps, that nobody can replicate.
Absolutely, I agree.
And you know, one of the themes that we brought up in our discussion on non-price effects of mergers was this idea that just because there's no variation between firms at the time of the merger doesn't necessarily mean that it's not a potential dimension of competition, right? So just because all the firms offer the same level of privacy protection doesn't mean that that level of privacy protection is potentially reflective of a lack of competition in the market on that dimension.
I mean, if you think of privacy protection as a quality attribute, then it may help you to think of, and we think about quality quite frequently when we're looking at mergers. This is just a somewhat unusual form of quality that takes some harder thinking. And we do have methods to think of quality in terms of a normal pricing analysis. So I agree that we don't want to we don't want to just avoid talking about privacy. We want to think when it's relevant and how to adapt it using the methods we have. We have a lot of available tools.
Hi, Maria Teresa Maggiolino from Bocconi University. My question goes back to business models. Suppose you got a scenario where you have two main business models and the profitability of one of them is seriously conditioned on the existence of anti-competitive clauses within the business model. At that point, what should we do? Should we strike down that business model even though this brings to a market where there is one single business model remaining, or should we tolerate somehow the existence of that business model with some anti-competitive clauses inside, just to guarantee that in the market there are at least two business models competing one against the other? Thank you very much.
I mean, I have two observations to make there, and I guess that they are going to be polemical, so I'm waiting for the responses of my co-panelists. First, I've never been persuaded by the argument that competition policy intervention should be limited by or should respect business models. To me, if a business model is fundamentally anti-competitive, I see no reason why we shouldn't go against it. The second point is a little bit more subtle, and that is that if a business model requires for its performance in the market the existence of anti-competitive clauses, I think that we have a fundamental problem. But it is also incumbent on the company that is using that business model to explain why those anti-competitive clauses are indispensable. Nobody forces a company to monetize in a particular way. We are all trying to see in which ways we monetize. And I don't think that monetizing in a particular way is an excuse for the use of anti-competitive clauses.
Well, I largely agree with what Jorge said, but I would imagine saying, let's imagine whether this business could survive if we force them to eliminate the anti-competitive part of the business and just fix it. But we have a lot of markets where private and public go together, and it may be the public component might be a component that would not work as a private model for various reasons, and we put them together successfully. I happen to be looking recently at some markets involving lumber, and so some of the lumber is owned on public land, some on private land, some of the processes for turning the lumber into logs vary. Some of that probably would be anti-competitive if it was all done privately, because there would be too much market power at the start of the level. So I agree with Jorge. I don't think we should accept business models that have anti-competitive behavior. We need to fix them and make them work.
I think the concrete example that your question brings to mind is the e-books case against Apple that both the US and the EC brought, where I think it was found that Apple's entry, so actually in a way almost their existence in the market was premised on an anti-competitive agency model with cross-platform MFN or whatever we agreed to call them, which was precisely aimed at restraining competition with the other platform, Amazon, and the two judgments on appeal in the US confirmed that entry as such doesn't justify the use of an anti-competitive clause precisely aimed at softening price competition once you enter into the market. I think that makes a lot of sense.
First, I would like to thank the panel for such a useful discussion. My name is Damani, and I represent the Competition Authority in Egypt. And I think this session has been very useful and very related to something that we are analyzing right now, which is the potential merger between Uber and Careem. Let me first explain a little bit about it so that I can ask my question. So in Egypt, we only have Uber and Careem competing in the ride-hailing platform in Egypt. So it's a two-sided market. And so the questions is about, first, defining the market. So whether should we define the market as platforms or transport, or even we have been thinking about defining the market from the driver side as a labor market. Because in Egypt, if you work as a driver for Uber or Careem, it's not easy for you to shift and work as a driver for the regular taxi or any other mode of transportation. That's the first question. The second thing is, how do we calculate the market share in such a dynamic situation? Because just the market shares, they change every minute or every 5 seconds, I would say. And fourth thing is the data. The data represents a very big barrier to entry, because we have had Uber entering the market first and has a huge database. And then for any rival, for any entrant to come into the market, they need to actually have access to the same driver database to be able to compete with the current Uber thing. The fifth thing, which is the last thing, is that the claim of innovation to be brought by both companies if they merge together. So the question is, how can we think about all those questions? I just need insights. I know it's a big situation, a big thing, but I just felt like you are the experts to help maybe say some insights about this complicated situation. Thank you.
A very comprehensive question.
So I was going to say, my advice would be that you hire Jorge, because he would be terrific.
But actually, I can't work in this case because my wife, who's sitting there, represents Uber, and I think that I have a fundamental conflict. It's not a legal conflict, it's not a business conflict, it's an existential conflict.
I have some advice too. I mean, I think in Singapore they looked at an Uber merger last year. It's in court, perhaps. Maybe there's something in writing there that can help all of your questions, hopefully.
And I would just say there's quite a bit of OECD resources. So if you're struggling with multi-sided platforms, for example, we had a discussion on disruptive innovation in the transport industry as well. But best of luck. It's okay. Maybe one final question, and then we will release everyone for lunch. Okay, well, if that's... Oh, I'm sorry, we have one more right up front here.
A simple question with regard to the information. Could make sense to use the old theory of essential facility doctrine in order to evaluate the data, holding the data, instead of try to find a zero price market?
Well, I mean, I can imagine a rare case where it might be useful, but I don't think it would be widely useful. What came to my mind was the case where Nielsen acquired a exclusionary contract with all the Canadian grocery stores to supply with scanner data, and then it effectively became a case that would fit your description. But I think it's pretty rare because the model, I think, of essential facility has probably been overutilized myself. I don't know whether others feel differently.
I tend to agree. I think that it's hard for me to think of a particular type of data that could not be replicated on its own, so that it could constitute an essential facility. I actually think that these days when we worry about data collection, we don't worry about collecting a particular type of data. We worry about situations in which different sources of data are combined together in order to create consumer profiles that cannot be replicated because of the sheer complexity and of that combination of data. And then it would be very difficult to say that that in itself is also an essential facility. So I guess that we need to think about it in a slightly different way than it was the traditional way.
Yeah, in my head, just to emphasize what I said before, when I think about data, I really think about scale and speed. There are huge advantages to scale, and more importantly, or equally importantly, there are huge advantages to getting the data quickly, because data are flowing all the time. New information is becoming available. We have huge volumes of data. And so it's not a fixed target. It's a moving target, and the question is how you get there fast. So the concept of essential facility doesn't seem to me to work terribly well there.
Okay, well, Dan, Jorge, and Giulio, thank you so much for your insights. I think it was a great conversation, and thank you all for tuning in. So we will break for lunch until 3 p.m., so if you could aim to be in the room just a little bit before 3 p.m., that would be great. Thank you very much.